Hi, my name is Lonnie Fish. I am the founder of the Liberty Law Team. If you're watching this video, you're trying to gain a little bit of an understanding of the criminal justice system here in Pennsylvania. This video is aimed to guide people to the very basics for those that don't have much experience in the criminal justice system or who've never been arrested before. But make no mistake, there are certain ways to win a case. In this webinar, I'm going to talk about the 3 secrets to winning your case here in Pennsylvania. I'll tell you a little bit about myself. I'm an attorney and I became barred in 2005. I founded this law firm in order to provide people with a very premium legal service. My main goal here at this law firm is to work as a team with my teammates to provide a better service. Started this practice right out of law school in 2005. And one thing that's very interesting about me is that I started at a very young age. In fact, I started going to college at 15 and law school at 20. And as soon as I got my bar card, I opened up my own criminal defense and personal injury practice. I found throughout my whole entire life that I really feel like I've been misunderstood. And in having this law firm and representing thousands of people, I can help give them a voice. I can understand their problems and I can understand how to make them better. My whole life, I felt misunderstood. And really, the way that I do things is different than most people. And really, it's been a curse my whole life. But now I've learned how to use it to my advantage and to my client's advantage. So here are today. And now you're looking for somebody to speak for you or your loved one, and that's me. As I stated to you earlier, the goal of this webinar is to give you a really basic understanding of the criminal justice process, as if you've never been arrested before, have very little experience in the criminal justice process. And at the end of this webinar, I'm going to reveal to you my secrets on how to win your case. But first, I want to talk to you about not just the arrest, but the pre-arrest, if you've been accused of a crime. So if you hear from a detective or if you've committed a crime and feel like you need representation, which you probably do, you would call my law office and we would represent you pre-arrest. And there we give you the very basic information and basic evidence to decide what to do and how to handle your case. More often than not, you're going to decide to remain silent and not speak with the police or have a proxy, such as myself, talk to the government on your behalf. Some of the benefits of having a lawyer at this stage are very clear. First and foremost, you can turn yourself in on your terms if there has to be a situation where you have to have bail. Sometimes I can get what I call the Holy Grail, which is a declination for them to file charges. And we get the best results when you hire us the soonest in the criminal process. One of the first things we do when you hire us is what's called an onboarding meeting, where we get your entire story so we can be able to tell your story to whoever need be. So for example, if you're getting bail set, we can appear in front of the magistrate who is setting your bail and tell them all about you. Now, if you get swooped up in the middle of the night without us knowing there, hopefully at that time, you'll be able to just call us and we'll represent you at that bail hearing. Obviously, without us there, you could spend weeks or even months in jail if your bail is set at an extraordinarily high rate. So it's important to get us involved right away, not only to make sure that your rights are protected, to make sure that you don't make any fatal mistakes in talking to the police or even talking to loved ones over the phone, and lastly, to make sure that your freedom is secured prior to the arrest. Now, almost as important as hiring us early on in the process, sometimes you can't do that. Sometimes people don't wake up in the morning and say, I'm going to get arrested today. So if you or a loved one has been arrested, you call us. Most likely after the arrest, one of the few things that either a preliminary hearing or some sort of preliminary arraignment has been scheduled, and you're going to want to call us right away. Now, a lot of people ask us, what's a preliminary hearing? I'll give you the answer in a few seconds. But one thing that's very important is that we consider the preliminary hearing to be one of the most important stages in your case. If you hire me at the preliminary hearing and your case goes to trial, I have a better chance of winning that trial when I'm representing somebody from beginning to end. Now, a preliminary hearing is a hearing that happens before trial and happens right away. It usually gets scheduled at the time your bail is set. Now, it's important to note that usually gets set within 3 to 10 days of when your bail's being set by the magistrate. And not always does that magistrate check the schedules of the officers, the lawyers, and everybody involved. So often that that hearing, that very first hearing, will be continued. But the preliminary hearing, the government has a very low standard. They have to prove, more likely than not, the crime has occurred and that you were the one who committed it. The judge at the preliminary hearing is bound to accept all credibility, to accept what the witness is saying to be true. And if true, is the crime that the government charged you with appropriate? Now, that seems like a very low standard, and it is, but there's a lot of very important reasons why it's important that you hire an attorney at this stage. We'll go through those reasons shortly. What happens in a lot of preliminary hearings is that people waive the preliminary hearings. In other words, they say, hey, we don't have to have it. Those are recommended only in certain circumstances. Sometimes those happen for reduction of bail or certain charges, or if you're applying for a particular program. But often we won't waive a hearing unless there's a really particular reason to do so. Now, at the preliminary hearing, technically, you're allowed to present evidence, although we rarely do. We rarely want to show our hand because that standard is very low and because that is bound to accept the witness's version of events. What I'm trying to do in a case where, for example, it's an assault where one person is accusing another of assaulting them, or is what I'm trying to do is to try to make that witness give an inconsistent statement to what they previously gave, or in the alternative, set up some sort of affirmative defense, such as self-defense. Now, one of the things I also will try to do is to try to minimize my client's involvement if there's a conspiracy, or even limit it to a particular part. Sometimes you ask the judges to drop charges. Now, one of the biggest myths that I see at this stage is that people feel that their preliminary hearing may not be successful because no charges were dropped. Or in the alternative, people think their preliminary hearing was very successful if a bunch of charges were dropped. And that's not really the case. My estimation, charges being dropped versus not at this level is not as important as people think. Setting yourself up for that trial or motion to suppress in the future, that's the most important part. One thing that's also important to know is that we can ask for bail reductions at the preliminary hearing, but one factor that you may not know is that if somebody's on probation or parole, there may be a detainer lodge, which means that you can't post bail until that judge lifts their detainer who the person's on probation or parole with. So even if the bail is $1, you sit in jail until that detainer is lifted. Sometimes that's until the outcome of the case, or sometimes that's after we file a motion asking the judge to lift that detainer. A few common things that we also like to discuss is that at the preliminary hearing stages and at all stages of this case, is that the witness in the case or the victim doesn't have the option of dropping charges. The caption of every case is the Commonwealth of Pennsylvania versus you or versus your loved one. So, for example, if the victim goes to court and says, well, I don't want the charges anymore, essentially, it's not their choice. The Commonwealth is the plaintiff in the case. A lot of people state that, oh, the government picked the case up. That's the case in every case. Every single case is the Commonwealth versus an individual. That is the case caption. Now, if a witness doesn't show up several times to a preliminary hearing, the judge will throw the case out because the government can't prosecute it. Often, locally, there's some verbiage used that, such as must be tried. That's not in the rules of criminal procedure anywhere, but it's usually local verbiage that indicates to a judge that if the government is not ready to proceed to the case, that the judge will throw the case out. So that is a very common way that cases go away at the preliminary hearing. After the judge hears the preliminary hearing and all the witnesses have testified, the court then decides what charges go forward. They usually look in the crimes code and will cite whether or not the government has met their low burden for each of the elements that are charged within the crimes code. So you may hear some argument between the lawyers of suggesting, well, maybe the government hasn't met their burden on this particular charge. That being said, once the case is held for court, what will happen is the judge will then list the case for an arraignment. An arraignment is a guarantee of the Pennsylvania Constitution, which is somewhat antiquated. Back in the 1700s, they used to not tell people what they were charged with and not give you the ability to plead guilty or not guilty. So the framers of the Constitution said that you're entitled to an arraignment after the preliminary hearing. Now, oftentimes, if my clients are out on bail, we'll file some sort of document with the government called a waiver of arraignment, so our client won't have to waste their time going, and I won't have to waste my time going to that hearing as well. but is a significant part of the stage where of the process where it matter then moves to the Court of Common Pleas. The arraignment triggers many different things, such as deadlines to file motions and deadlines for the government to pass over discovery. In a nutshell, discovery is statements, the videos, DNA evidence, any scientific evidence, any reports filed by police, or any other sort of evidence that would essentially be used by the government against you, or could be what's called exculpatory, which should be used against the government in their case. It's a very complicated situation, but just make no mistake, we have some fail safes at our law firm to make sure that there's no discovery missing. We have exhaustive checklists that we've compiled after trying thousands of these cases or after speaking with many, many attorneys. Would like to note that after the arraignment, many cases are then listed for what's called a pre-trial conference. That's very common in many counties, although it's not guaranteed by the Constitution. Only thing that's guaranteed by the Constitution is the preliminary hearing, the arraignment, and then your trial within a speedy amount of time. You may have heard about a speedy trial. Speedy trial rules are also complicated, but in a nutshell, the government has 365 days to prosecute you from the time of your arrest. 180 days after your arrest, if you're in custody, then you're entitled to nominal bail. There's many different things that extend that 365 days, such as you applying for a program, or you asking for a continuance, or just the court being clogged up. But it's important to note that after the arraignment, usually when the exchange of discovery happens, we also file pretrial motions. One common pretrial motion would be a motion to quash or a habeas petition alleging that the government or the judge made a mistake at the preliminary hearing and certain charges should be thrown out. Another common motion that we would file is a motion to compel certain discovery if we feel that the government hasn't provided us the proper discovery, as I mentioned earlier, that we feel is mandatory. Also, we conduct our own investigation at this time as well. At the pretrial conference, usually there's some discussions about non-trial dispositions, meaning guilty plea. Now, not every case is a jury trial win. Sometimes a win in a case is getting a good deal on a case or a settlement of some sort. Now, one of the things that we like to do is to gather mitigation at this level and do our own investigation, so we know whether or not we want to go to trial or not at this point. What is mitigation, you ask? We use the term mitigation to signify things that are, in other words, good things about you, such as letters of support from family members, your resume, any tax records or W-2s or pay stubs that you may have. We like to get any mental health records or physical records or any medical records of your own. We would also like to get any schooling, any volunteer work or extracurricular activities, just to give the government or the judge an idea of what you're about. Now, sometimes if the decision at this time is to come to some sort of settlement, there's two ways of going about it. One is to come to some sort of agreement with the government, and the other is to not have an agreement, and that's in that case you would do what's called plead open, in which case you would agree on the charges, but the judge would then sentence you. Usually there's a chart where the judge will look at the charge, look at your prior record, and then start from there and then move up or down depending on what your mitigation is, if that's what you're trying to do. It's a very complicated process, but that's in a nutshell. One very common way that we would win a case is through what's called a motion to suppress. That's another type of motion that we would file pre-trial. Motion you can file to suppress statements, anything seized from you or about around you, or in the alternative, identifications of you. Let's start with the last one. You can ask the judge to throw away an identification. Maybe it was unduly suggestive, or maybe it was done under duress, or maybe the person who identified you was suggested that you were that person. Also, statements made by you could be suppressed as well. Some reasons for suppressing a statement would be if you were not Mirandized, or if the statement was given under duress. Now, the most common motion we file is a motion to suppress anything seized from you. This is a way that we can win a case, even if you are guilty of what you're charged with. Now, you say, well, how does that happen? Well, if I convince the judge that the police went about recovering tangible evidence in a way that violated your constitutional rights, that judge will order the fruits of that illegal search suppressed meaning the government can't use that evidence. The most basic example would be if the police pull you over and you have some sort of contraband in the car, such as a gun or drugs. And in that situation, if that contraband is recovered by an illegal search of the vehicle, the judge will say that they order the motion to suppress be granted. There's a lot of change in law with regards to vehicle searches and searches of a person. There are some instances where somebody will run, throw something away, and then we call that forced abandonment if the police chase you for no reason and you throw something away. Also, sometimes we can move to suppress cell phone records or anything else obtained illegally. This is a very complicated area of the law, and it would take me hours, if not days, to go through it with you. But those are the very, very basics of that. Next comes the trial. Now, at your trial, the government would have to prove your guilt beyond a reasonable doubt. That standard is much higher than when at the preliminary hearing. And there's two types of trials that you could take. You could take a trial by judge or a trial by jury. A lot of times people ask, well, what sort of trial should I take? That answer to that is that it depends. One of the first things it depends on is who the judge is. The other thing that depends on what the facts are. In certain circumstances where we're arguing police credibility, in my experience, some judges aren't likely to find a police officer to be incredible. So in those cases, we may ask for a jury. In certain circumstances where we have a very legal defense, such as one of mere presence or another legal sort of defense, maybe we want to put that in front of a judge. Some judges, in my experience, almost never find people not guilty, and some judges are very lenient and find people not guilty all the time. So a lot of it's going to come down to a judgment call of between the attorney and the client. But make no mistake, this is something that's always the client's decision and not the attorney's decision. Also, the decision that's the client's and not the attorney's is whether or not the client wants to testify. This time you can remain silent if you wish, and that can't be held against you. And at this time, you could present evidence or testify. The basics of how a trial would go is the government would have to present testimony and evidence from witnesses that they've given us advance notice of. And after they've provided us all discovery, they would try to present all the evidence to prove your guilt beyond a reasonable doubt on each and every element of what you're charged with. And it is my job after their witnesses testify to do what's called cross-examine their witnesses. And in other words, ask them questions. After the government presents all their evidence and testimony, they rest, and then we have the option as a defense to present evidence. After we present evidence, or we decide not to, we rest, and then we make our closing arguments to the judge or to the jury. That's the trial in a nutshell. But in the unfortunate event that somebody loses a trial, after the trial, there's certain post-trial motions that must be filed, and there's lots of appeals that can be filed that we can do. In fact, we have a post-trial division that specializes in PCRAs, direct file appeals, and other sorts of appellate issues in this state. Feel free to look at our other content to answer questions about those events. I did my best to try to give you the 101 of criminal justice system in Pennsylvania. And sometimes these issues can be complicated, and you can feel free to check us out on our YouTube channel for some of our more complicated things, some of our more complicated topics. And we as a team work together to make sure we're on top of the law and giving a premium service. You have your choice of many different attorneys, and we here at the Liberty Law Team strive to give you a personalized and premium service. So earlier in the video, I told you we would tell you our 3 secrets on how to win your case. Well, the first secret is to be able to tell the story the best. And I know that sounds strange, but sometimes lawyers come into court and they yell and scream, and it's not about who yells the loudest or who barks the loudest. Sometimes that could be very comical, and it may have a good theatrical look, but that doesn't win cases nowadays. Maybe that did 20 years ago, and maybe it's interesting to watch, but just yelling and screaming at the cops doesn't get you a win these days. It's being able to tell the judge or the jury the story. That's the number one. Number 2 is very is the number two is very obvious, and that's hard work. Is there one person working on your case? Is there one person keeping up on the law to make sure they're on top of all those very complicated legal issues with regards to motions to suppress, with regards to different elements of the crime? Is there a team working on strategy of your case? That's the second secret, which is hard work and manpower, which brings me to the third secret on how we win cases, and that's through teamwork. There is a Stanford study that said when people worked on a task as a team, they persisted 48% more than when they did individually. They were less tired and they performed better on the task. We are the Liberty Law team. This is not a sole practitioner. I'm not a sole practitioner of criminal defense. I have a team behind me. We strive to work together to help you win your case. That 48% was not done by a community college. It was done by Stanford. We believe that in teamwork, we can provide you the best of results, and we try to give you an edge in every single way. One example of how teamwork works in our law firm is that we'll have strategy sessions, which we tape and then send you a copy of it talking about your case before it goes to trial, before it goes to a hearing. I've had instances where me and another member of our team will sit and talk about a case. And in the middle of the strategy session, we each individually going into that strategy session had no idea how we were going to win the case. And then after the strategy session, we had no idea how we were going to lose that case, that it was a slam dunk. And not only are two minds better than one, but six minds are better than one. And that is this third secret to winning your case. Now, you're watching this video and I appreciate your time. Either you or somebody in your family has been charged with a crime by the government and they're looking to take away your freedom, to take away your liberty. I don't support crime and I'm not a criminal, but I do want people to be understood. And I do know what it feels like to be misunderstood. And as I stated earlier, my whole life, I grew up feeling that I've been misunderstood because I go about things differently than anybody else, because I think about things differently and I do things differently. And that's made me be the best lawyer that I can be. And as I've practiced law, I've realized that me doing it alone isn't the best way to do it. Doing it with a team is what delivers a premium service. Now, when you hire our team, the first thing that happens is that we have what's called an onboarding meeting. At that onboarding meeting, we not only hear about your case, but we hear about your background and your life story. As I stated earlier, that barking and screaming in court isn't what gets the job done. It's who can tell you the story the best. And if your lawyer is not asking you about your work history, your mental health history, your background, how are they going to be able to tell the story? Winning results come with hard work. As soon as you get hired, we will have that onboarding meeting to make sure that we start on the winning track. I tell people this all the time. If you're trying to win a race, you're not going to ride a bus. That bus is that law firm or that lawyer that does the same thing for everybody. It's not individualized. That bus is made for the masses. Our firm is not the bus. We tailor your representation to you in each and every individual case. A few other features of our law firm is essentially the use of technology to not only ensure that you're getting a premium service, but it's also to ensure that your experience is as good as it can get. I've been hired by thousands of clients, and the number one complaint about other attorneys is not the results. Ironically, it's they didn't call me back. We have easy ways to fix this, and I love representing people, and I love getting as many clients as possible. So we have a real easy fix. We use technology to fix it. There are several ways to talk to us, whether it's social, whether it's text, Zoom, call, email. But we have a daily meeting and a single person in our law firm that's dedicated to make sure that you get responded to. Every day, we have a client contact meeting in our law firm at a particular time of the day. At that time, the whole world stops and we go through each and every contact that has been sent to us to make sure that that person is responded to. So if you call our law firm on a Monday at 11, rest, but you get a call back, or you will get texted, you will get email that somebody has addressed your concern. Your concern will be handled by the next daily contact meeting. We also use technology to make sure that you can see exactly what we're doing. We have nothing to hide. The lawyers that do the same thing every time, which is you can't, when you pay a lot of money to a lawyer and you want to know what they're doing, we share our files with you over Google Drive or Dropbox or whatever other file sharing we have. We'll share everything that the government gives us with you within the parameters of the law. We'll make sure to give you text reminders and tell you about each and every court date. In fact, if your loved one is in custody, we'll make sure that they get communicated to you on a regular basis, depending on the type of case. So for example, if you hire us on an appeal, sometimes those appeals could take over a year or even 2 years. However, we have a policy in those situations to make sure that our clients are hearing from us at least once a month. I've heard horror stories where sometimes people hire a lawyer and then they won't hear from them until the end of the case or at all. At our law firm, we also use technology to make sure that you're getting a premium service. As I suggested earlier, you don't always know what you're getting when you pay for that attorney, but we have exhaustive checklists that no other law firm in this area I've seen use to make sure that we are not only conducting a proper investigation and turning every stone over, but we also have every single piece of discovery. We also conduct our strategy sessions and tape them and share them with you so you can see exactly what we're doing. We have procedures and guidelines for almost everything that could happen, whether it be for gathering mitigation, investigating a crime scene, or dealing with a DNA expert. We have procedures for all of those things and beyond. We use technology to make sure that we're keeping to those procedures and improving them when need be. You may see us post up some videos online, and you may see us on Instagram or Facebook or wherever on social media, and some of them are fun, but some of them are meant to showcase our knowledge and to show you that we know what we're doing. And in fact, this video, hopefully after watching this video, even if you don't agree with some of the things I'm saying, you at least can see that I can argue for you in court if need be. Often when people are faced with criminal charges, they're looking at losing their liberty. I've seen certain people, when they're selling their service, they say, what would it mean to you if you lost your case? I ask you, what would it mean to you if you won your case? Sometimes the lawyer does not make that big of a difference, but often it does. We are not always working on margins. Hiring the wrong lawyer or going with the wrong law firm can be devastating to you and your future. No lawyer is cheap, and neither are we. However, we have our procedures in place so you know exactly what you're paying for and to make sure that you're getting a premium service. It could be an extraordinarily painful event to be arrested and then not only waste money with the wrong attorney and law firm, then lose your liberty on top of it. I know what it feels like to be misunderstood. I don't want you to sit there or your loved one to sit there in court not feeling like someone is speaking on their behalf, not feeling like somebody can't even tell the story because they haven't met with their client and they don't know their background. Sometimes it would feel like being a passenger in a bus, not a passenger in your own automobile. We get better results when we start earlier. And as I said before, the biggest feature that we give is our teamwork. And statistically, you're better off hiring a team than an individual. So if you've been injured or arrested, please don't hesitate to call us to discuss your case so we can get together and come with a plan of action to move your case forward so we can win.